Mike Dooley, at the end of this academic year, will retire after 44 years in teaching, of which 41 have been at the University of Virginia. Mike has been a mentor as well as a colleague to me. We work in the same substantive fields of corporate and securities law. Moreover, when Mike first came to the law school in 1971, he was told that the law school's interest in him stemmed in part from the fact that Ernie Folk needed help in handling the corporate and securities law curriculum. When I joined the law school faculty in 1990, I was told the same thing, making Mike and me perhaps the only two professors in the country hired 20 years apart to spell the same person. But Mike's presence at Virginia was a big part of its attraction for me. Mike received both his undergraduate and law degrees from the University of Iowa. He practiced for 5 years with Dewey Ballantine in New York. Mike, I hope you're not looking to them for part of your pension. And then began his academic career in 1968 at the University of Illinois, where he joined our other honoree, Jeff O'Connell. In the fall of 1971, Mike came to Virginia for a visit. Years later, displaying his trademark wit and lack of self-importance, Mike said, "My chief qualification was the fact that I was available." Even had that been true at the time he was asked, it would not remain true. During that visit, Mike published in the Virginia Law Review a magnificent article entitled "The Effects of Civil Liability on Investment Banking and the New Issues Market." The piece can fairly be called one of the pioneering efforts in the economic analysis of corporate and securities law. More importantly, its analysis was so penetrating and prescient that the passage of 40 years has not dimmed its insightfulness and influence. Much of the article contrasts the civil liability scheme of Section 11 of the Securities Act of 1933 with the implied cause of action under Rule 10b-5 adopted under Section 10b of the Securities Exchange Act of 1934. The former was the result of an explicit legislative balancing of the interests of buyers and sellers of new issues of securities. As such, it represented, however imperfectly, an attempt to weigh both the social costs and benefits of liability. The same was not true of the judge-made cause of action created to allow investors to enforce an SEC rule not written with civil liability in mind. What put the article so far ahead of its time is that Mike did not undertake merely the standard lawyerly exegesis of the similarity of Section 10b to the common law of fraud and the concomitant limitations that one would expect to see applied to the cause of action, thus anticipating a line of Supreme Court cases that would come later in the 1970s. The article also analyzed the likely impact of those substantive legal standards on the expansion of the class action device pursuant to Rule 23 of the Federal Rules of Civil Procedure as they were amended in 1966. Mike observed that the efficient maintenance of a class action was inconsistent with the application of traditional fraud concepts such as reliance and transaction causation, and predicted that courts would erode those concepts for purposes of Rule 10b-5 class action litigation. Thus, the cause of action over time would come to resemble negligent misrepresentation rather than fraud. The combination of a low standard of proof, an almost unlimited plaintiff class, and no privity requirement would mean that Rule 10b-5 would not serve as a means to force sellers to internalize the cost of their misstatements, but instead would effectively become a tax on securities transactions. Seldom has a law professor made predictions so novel and non-obvious only to see them so thoroughly vindicated by subsequent events. Mike's article remains rightfully part of the canon of law and economics of business law. Mike joined the faculty permanently in 1972 and began a long friendship and occasional collaboration with our late colleague John Hetherington. That collaboration bore fruit in another influential article, Illiquidity and Exploitation, a Proposed Statutory Solution to the Remaining Closed Corporation Problem, published in the Virginia Law Review in 1977. Prior to that article, there was a move to supplement corporate statutes by adding provisions specifically designed with closely held corporations in mind. These proposals were motivated by the idea that the detailed organizational rules set out in the typical corporate statute were overkill as applied to closed corporations, and they required a more flexible set of rules. Dooley and Hetherington showed that this was not an important problem facing closed corporations, which explained why so few of them bothered to make use of these new statutes. The problem closed corporations faced, they pointed out, was lock-in. Once minority shareholders invested, they could not easily exit, and majority shareholders could exploit that fact. John and Mike argued that the solution to the closed corporation problem was to provide greater liquidity to minority shareholders and proposed a statutory buyout right. Later, as a member of the Corporate Laws Committee of the American Bar Association's section of business law, Mike was able to champion the addition to the Model Business Corporation Act of a limited buyout provision in lieu of dissolution in cases of majority shareholder oppression. As this example shows, Mike maintains strong connections to the world of practice during his time in the Academy. He has played a leading role on the Corporate Laws Committee, one of the few ABA committees for which membership is by invitation only for almost 30 years. Alan Goolsby of the class of 1968, who is with us today, also serves on that committee. In 1996, Mike became the reporter for the committee. He continues to serve in that capacity today and has now done so for longer than any of his predecessors. As reporter, he has overseen publication of all changes to the Model Act, including periodic updates of the multi-volume annotated version, which is one of the ABA's best-selling publications. Norm Vesey, past chairman of the committee and former Chief Justice of the Delaware Supreme Court, expressed the extraordinarily high regard that the other members of the committee have for Mike. He emphasized that the members deeply appreciate, quote, Mike's exceptional intellect, quick wit, and unwavering commitment. Mike, your colleagues feel the same way. We are sorry to see you go, but wish you and Jean many happy years of retirement.
Well, I am gratified to see so many of my former students in the audience, and just to be clear about it, everyone who is here was among my very favorite students. I remember you fondly. Paul pointed out that when I came to Virginia in 1971, I came as a visitor. And what that means basically is that you're on trial. This is kind of layaway, and if it works out, then you get brought on. And obviously, teaching would be an important part of any evaluation that the school was going to do. Well, in my first class, I had as a student one J. Harvey Wilkinson, who was, I knew, a member of the Board of Visitors at the time. Unfortunately, we did not have easy access to photographs of the class in those days, and I had picked out one blonde. And for those of you who know Jay only recently, he did have hair at one point, and it was blonde. I had picked out one blonde student whom I had identified in my own mind as likely J. Harvey Wilkinson. Well, from time to time, I would sneak a look just to see how I was doing with this student. And his expression was somewhere between aghast and Monk's The Scream, suggesting perhaps that things were not going so well. Well, fortunately, at the end of the semester, I discovered that I had the wrong student marked as J. That student, in point of fact, was fine with the class. That was just his normal expression, apparently. So we went on from there. Paul mentioned my time on the Committee on Corporate Laws, which has really been one of the most rewarding experiences I've had. And it's relevant, I think, that my initial appointment there came through the intercession of one of our own alumni, who was a partner of Elliot Goldstein at the firm, and Elliot was at the time chairman of the committee. From there, I went on to have the honor and tremendous experience of serving with the ABA's liaison committee on the ALI's corporate governance project. From that, I went on to membership on the legal advisory committee to the board of the New York Stock Exchange, and from that, my continuing appointment as a reporter for the committee. So for all of this, I owe a great deal of gratitude to our own alumni. It is, I think, a mark of the distinction of this school that even though this is a very select committee, it's sort of a who's who of corporate law, it's very limited, 25 members, we have, by far, the largest delegation. Ahead of, there's a school in Boston someplace, or Cambridge, that has a couple of members. But at the moment, the Virginia Mafia, as I'm inclined to call it, consists of Robert Walmsley from New Orleans, Bob Thompson from Georgetown Law School, David Martin from Covington and Washington, and Alan Goolsby from Hunton & Williams. Now, I'm at least an honorary member of this Virginia Mafia because I taught all of those, with the exception of Goolsby, who, of course, is much too old to have been my student. As Paul mentioned, I have spent the bulk of my career here. I have had a number of opportunities to go elsewhere. And when contacted, my way of handling this was to say, well, I need a few days to think about this, and I need to talk to my wife. I was being polite. I didn't need a few days. I didn't need to talk to Jean. There was no place else that either one of us ever wanted to be. Thank you.